Hi, sorry to interrupt your lunches, but we're about to get started. So good afternoon and welcome to the Marian Minor Athenaeum. My name is Jessica and I'm here on behalf of the Dreier Roundtable to invite you to listen to the wonderful group of panelists that we have here today. Today's panel is called After Scalia, the Politics of Supreme Court Nominations in an Age of Polarization. So as most of us now know, the Supreme Court has recently been rocked by a shocking and unexpected event that will change the character of the court as we know it. For the first time in a decade, Justice Clarence Thomas has asked a question from the bench. So that's something we never saw coming. But in all seriousness, the court and the country are both reeling from the recent death of Justice Scalia. And there was colorful commentary and staunch defense of originalism cemented his legacy on the bench. It is now his absence that dominates the public conversation. Scalia's sudden death leaves in limbo the bench's ideological balance in several pending cases. Furthermore, his vacant seat in a presidential election year has sparked a political battle between President Obama, who can nominate Scalia's successor, and the Republicans in the Senate, who have the power to confirm or block a Supreme Court nominee. To help us understand what might emerge from this, we are joined today by three of the Claremont College's finest professors of constitutional law, Professor Amanda Hollis-Brusky of the Politics Department at Pomona College, and Professors Kenneth Miller and George Thomas from Claremont McKenna. The panel will be moderated by Professor Zachary Courser, who is the research director of the Dreier Roundtable. So please join me in inviting them to the
Thank you, Jess, for that fine introduction, and my thanks to the Dreier Fellows, and also to Priya Junar for putting this on the schedule in such short notice, and to all of you for signing up. We're very pleased that our topic has proved so interesting and so topical, and we're very happy to join you to discuss it. I also want to mention, too, that this in part is related to the Dreier Roundtable's project this year on polarization in politics, and some of my questions will focus on this question of the constitutional roots of polarization. So that's something that I want to explore in discussing the legacy of Justice Scalia, to think about the current court and how his absence will affect decisions, and also thinking about the nomination process. These are all, and obviously the presidential election that's going on right now also weighs in our considerations about the future of the court as well. So plenty to talk about in less than an hour. Let's see if we can do it. So first of all, I wanted to talk a little bit about the Scalia legacy. Justice Scalia actually stood here at this podium 9 years ago at Claremont McKenna College. Scalia had an outsized personality, certainly in the context of the Supreme Court, and he was very much unique in the way in which he approached his job as a jurist. He described his own jurisprudence as textualist. Or, if pushed to it, he said, "I'm an originalist, not a nut." He had a particular way of approaching cases that certainly influenced his fellow Justice Thomas, but I think that's a good place to start in terms of talking about his legacy, is talking about his jurisprudence as an originalist and exploring really what that meant. So, George, why don't I turn to you first? Could you tell us a little bit about Justice Scalia's jurisprudence as an originalist?
Well, I mean, I think that will be his most enduring legacy, and I agree with Amanda that despite what some have said, I think originalism, as Scalia practiced it, is here to stay. I actually want to raise the question of whether Scalia is a particularly good originalist. I think that's something that we should talk about when we talk about Scalia, but I think it's not just that Scalia brought originalism sort of front and center again to his constitutional jurisprudence. It's also that he gave it a vibrant intellectual defense. And if we're looking for some of the things that I think Scalia did that aren't just important but are serious improvements in how we think about constitutional law, I would say Scalia gave the court a seriousness with which in the middle years of the 80s it did seem to lack in terms of its constitutional reasoning. If you think of the justices across the court these days, the the opinions, I think, are much more powerfully written, logically reasoned, and grounded than some of the justices' opinions from the sort of late 70s, mid 80s, when you could say that it was not sort of the finest moment in the court's constitutional reasoning and thinking. And Scalia has had a powerful influence across the political divide in that way. I think that textualism is taken much more seriously than it was before he came to the court, and turning to originalism. So I think one of the great originalist opinions in recent years was actually written by Justice Stevens, who had not really been much of an originalist prior to Scalia coming on the bench. It's also interesting, though, in some ways, I think that that legacy will get picked up and it's taken seriously, but Thomas is really the only originalist left in sort of Scalia terms on the court. So, that legacy will be interesting. I do think also, just one last quick thing, and then we can maybe get to the substance of his originalism. I think he also really changed oral argument. There's a great question of whether this is to the benefit of the court's reasoning. It's certainly to the benefit of all of us. Oral argument is much better to listen to now. It's like a constitutional seminar. And the others have all engaged in it as well. I mean, Thomas is, of course, the outlier there. Even he is maybe trying to pick up the baton of Scalia a little bit. But the court is much more active than it was. I mean, when Scalia was first on the bench, it was Lewis Powell who looked at his fellow justice and said, "Do you think he knows that any of the rest of us are even here?" So it was this sort of more somber court, and they really let attorneys go. That's just not the case these days. And I think Scalia profoundly changed the court in those ways, and it's a more visible institution in that regard as well.
Amanda, I wanted to ask you a follow-up question related to that, and that is originalism here to stay? Does it survive Scalia? And then secondly, just for people who may not be totally familiar with what we're talking about, could we briefly describe what we mean when we say originalism or textualism?
Yeah, sure. So the short answer is yes. In fact, shortly after Scalia's death, I penned an op-ed in the Washington Post in response to Eric Posner, who had written a piece for Slate and had predicted the end of originalism with Scalia's death. And I penned a piece with the title, "Here's Why Originalism Won't Be Buried with Scalia." And so my entire argument was basically talks about Scalia as an important figurehead, as George said, for originalism, maybe its most visible and vocal advocate. But certainly, he wasn't always the most faithful originalist, according to many within the conservative legal movement. So my work my earlier work was on the Federalist Society for Law and Public Policy Studies. And so in the context of that work, I interviewed a number of the founders of the Federalist Society. And Antonin Scalia was the first faculty advisor to the Federalist Society when it was founded in 1982 as a small student group at the University of Chicago. And in inspiring the founding of the Federalist Society, Scalia sort of put his imprimatur on that organization and helped start an organization that would make originalism the forefront of its intellectual agenda. In doing so, while he was on the bench, the Federalist Society sort of grew up and became really strong and vocal proponents of the theory of originalism, and in many ways outgrew Scalia's own originalism. So originalism is the idea that you interpret the Constitution according to its original public meaning. Originalism has gone through various incarnations throughout the last 30 years, but that seems to be sort of the most generally acceptable way of thinking about originalism. And as George pointed out, this was quite radical. This was a quite radical theory prior to the 1980s. People were laughed out of law schools for believing that you should interpret the Constitution according to its original public meaning. And what's happened, in part because of Scalia, in part because of the rise of the Federalist Society, and so the conservative turn of national electoral politics, is that this has become the mainstream. This idea has become the mainstream. Certainly it was on the Supreme Court, where you saw liberals responding to conservatives in the discourse of originalism. George mentioned that maybe the best originalist opinion was Stevens' originalist opinion, probably in Heller, is that, yeah, in the gun rights case. So Scalia writes what he thinks is an originalist opinion, reinterpreting the Second Amendment. And then Stevens, in dissent, writes his originalist opinion, saying, no, the Second Amendment actually, if you look at the history and take it seriously, provides for a collective right to bear arms. And so I think one of the things to remember is that Scalia's originalism would outlast him because he helped form an organization that will carry it forward and push it further and deeper than he was even willing to go on the bench. And that the real originalist on the court right now, the one that the hardcore originalists look to, is Clarence Thomas. And so he will carry it forward for the time being.
Before I move on, Ken, do you have any comments?
Yeah, just one comment. Scalia was well known for his statement that he opposed the idea of a living constitution, and he said that the Constitution is dead. Dead, 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 right? And by that he meant that the text is fixed at the time of ratification, whether it's the original Constitution or the amendments that came thereafter. And so the court should be bound by the public meaning of the document, not subjectively what was in the heads of the drafters or the people who ratified it, but what was the public understanding of the word at the time. And so that the justices in 2016 shouldn't be trying to import new meaning into the words of the Constitution given social evolution, but instead be bound by the understanding of the words as they were drafted at the time of the ratification. So that's a key concept, is that he really believes that judges should be limited to the meaning of the text at the time the text was ratified, and that if people want to change the text, there's the availability of constitutional amendment, which everybody acknowledges is extremely difficult under our system. But there's also the opportunity oftentimes for social change through ordinary legislation as opposed to through new constitutional interpretation. And that was his preference, was if there's going to be a change in social policy or other kinds of policy, it should be done through the democratic process as opposed to judges reinterpreting the meaning of the Constitution.
I want to follow up on that idea of the role of the court within our democracy, within separation of powers. And I also want to explore a little bit Justice Scalia and his personality and how it was reflected in his decisions. I mean, we would be doing a disservice not to give everyone a taste of his pen, so to speak. He could be quite the arguer, particularly in his dissents. They were heated, they were pointed, they were witty, and oftentimes they were brilliant. And in oral arguments as well, we discussed already, and I hope we'll discuss a little later, how Justice Scalia was such a pivotal part of oral arguments, his again, wit and intelligence. But I want to read you a few quotes from some recent decisions that Scalia weighed in on to give you a taste of his jurisprudence and also of his style. So Scalia, in a footnote to Obergefell versus Hodges, you might remember that as a recent case that legalized same-sex marriage across the United States. Scalia writes, in talking about whether he should join a majority opinion that Scalia has written, he says, "I would rather hide my head in a bag." Did you catch that? The Supreme Court of the United States has descended from the disciplined reasoning of John Marshall and Joseph Story to the mystical aphorisms of the fortune cookie. Describing the majority opinion in King versus Burwell that involved a decision about Obamacare, he alternatively described the decision as pure applesauce and interpretive jiggery-pokery. But I think, going off of what Ken was just saying, at the core of Scalia was a concern about separation of powers, the role of the court, and a balance between the court and democracy. And I wanted to read a couple of quotes that reflect this and then ask some questions about it. So Scalia wrote in U.S. versus Windsor, which you also might remember, it struck down the Defense of Marriage Act. He writes, "It's about the power of our people to govern themselves and the power of this court to pronounce the law. Today's opinion aggrandizes the latter with the predictable consequence of diminishing the former. We have no power to decide this case, and even if we did, we have no power under the Constitution to invalidate this democratically adopted legislation." And then another quote from his dissent in Casey versus Planned Parenthood, a decision that is reconsidering in terms of its definition of undue burden. We'll talk more about that. He writes, "By foreclosing all democratic outlet for the deep passions this issue arouses, by banishing the issue from the political forum that gives all participants, even the losers, the satisfaction of a fair hearing and an honest fight, by continuing the imposition of a rigid national rule instead of allowing for regional differences, the court merely prolongs and intensifies the anguish. We should get out of this area. We have no right to be here, and where we do neither ourselves nor the country any good by remaining." So George, I guess I can start with you again. How do you see Scalia's vision of the court within separation of powers?
Well, I mean, I think Scalia, the thing to understand about his originalism is it's really being driven by his understanding of the role of the court. And Scalia is concerned that the role of the court in a democracy needs to tether itself to something. And that something becomes, as Ken described it, original meaning. And that is the understanding of the public that ratified the Constitution or the amendment at the time it was ratified. Now for Scalia, that binds us as a citizenry because it was an act of we the people, right, in a democratic society, and therefore justified our carrying it forward in those terms, and then allowed us to amend it by way of Article 5 of the Constitution. And so Scalia's concern was that when a justice would depart from original meaning, as based on the public understanding, there would be nothing to turn to, right, other than sort of their own internal moral compass, as Scalia would describe it. And so for Scalia, the problem of legal interpretation and constitutional interpretation in particular is that a judge or a justice confronted with a text, particularly a constitutional text, needs to ground and discipline their judicial will. He's deeply concerned and driven by the problem of judicial lawmaking. And so when you think of the separation of powers, to speak to Zach's question, I mean, his concern was that the court would be overreaching in these areas and taking on things that properly belonged either to the political branches of government or to the people themselves. I want to push here just a little bit because I think we should open the question up. It raises a good question of Scalia's textualism and originalism, I think, because it's not like there's anything in the text of the Constitution that says, well, what we should be really driven by is binding judicial will. That's not a textual provision. I mean, one has to have a theory of the Constitution, the judicial role, the nature of democracy, and the like, to make that kind of argument. And Scalia's textualism is odd on occasion in that he wants to close text down in many ways. And this was sort of most evident in a reasonably recent, I think 2010 opinion during oral argument, and he was great and witty and funny. The counsel was trying, this is Chicago v. McDonald, which was a 14th Amendment case. It was the 14th Amendment case that raised the question of whether or not the Second Amendment right to bear arms was either incorporated by way of the 14th Amendment's due process clause or somehow protected by the 14th Amendment understanding of liberty or privileges or immunities. The 14th Amendment actually starts with privileges or immunities. Most scholars, including most originalist scholars across the political spectrum, think that the court got the privileges or immunities clause wrong very early on in the 1870s. It's been sort of erased from the Constitution for over a century in that regard, and counsel was trying to revive the privileges or immunities clause, right? And it's textually there. It's not like the privileges or immunities clause sits outside the constitutional text somehow. It says privileges or immunities. It then doesn't also say, oh, and here's what we mean by privileges or immunities. I mean, that's something that we then have to turn to history and the like to understand. Scalia wanted nothing to do with it, right? When the counsel was making the argument, Scalia said, yeah, you know, I get it if you want to be consistent with theory and everything, but that, come on, what are you, bucking for a position on a law school faculty, you know, or the court? That's pretty dismissive of potentially original meaning in interesting ways, and I would also say text. And so, I mean, I think when we think of Scalia's understanding of the judicial role and why he turns then to textualism and originalism to ground and guide the judicial role in a democracy, I mean, to understand his thinking there, we need to understand that he is really being driven by the concern about judicial lawmaking. And there's a question is that concern compatible with original meaning, original intent? Because there are times when it may be that original meaning points to or requires or asks justices to engage in more abstract thinking that I think Scalia was comfortable with. And you sort of saw this with the conservative movement really starts out speaking the language of judicial restraint, much like sort of the New Deal justices before them. But what happens when judicial restraint doesn't go along with original meaning? We didn't think about that as much, and Scalia later wrestled with that dilemma, but that dilemma is one that I think Scalia needed to confront much more explicitly than he did.
And just a quick point on that. This is
we're going to disagree, I think.
A point of distinction between Justice Scalia and Justice Thomas, who are often seen as being basically the same in their jurisprudence. Justice Thomas was, in that case, the McDonald case itself, and in other cases, much more interested in drilling down to the actual original meaning of the text than Justice Scalia was. So
yeah, I think that's right. He was the one justice in McDonald that said, actually, we should return to the Privileges or Immunities Clause.
Yeah, and I'd like to shift. I want to talk about the separation of powers too, because I think so often we think of Scalia and we remember him for his colorful language, right? But he thought his biggest legacy that he would leave would be his separation of powers jurisprudence. Part of that is the proper role of the court and scope of the judiciary, but part of that is negotiating the balance of power between the federal government and the states, and also the branches of the federal government. He taught Con Law 1 at the University of Chicago, separation of powers. That's where the sort of founders of the Federal Society first took his course and were inspired by him. Their statement of principles really reflects his view of the separation of powers. And I was at an event, a Federal Society event in 2008 when I was researching my book. And Scalia was speaking on his book, Making the Case, The Art of Persuading Judges. And he opened it up to questions, and a young law student raised his hand and said, what do you think your most important opinion is? And he just paused for a moment and he said, my dissent in Morrison versus Olson. Morrison versus Olson is a rather obscure 1983 separation, or late 1980s separation of powers case about the independent counsel provision in the Ethics in Government Act. Now, why was this his favorite opinion? He started to recite part of his dissent, right? And I'll read part of it now. And why I'm going to read it, you'll see in a minute. He says, frequently an issue of this sort will come before the court clad, so to speak, in sheep's clothing. The potential of the asserted principle to effect important change in the equilibrium of power is not immediately evident, but this wolf comes as a wolf. His point there was these nuts and bolts separation of powers cases, they're not the sexy cases, they're not the cases that generate a lot of media interest, but they're the ones that could fundamentally restructure power in government. And he saw the independent counsel provision in the Ethics in Government Act as a wolf in wolf's clothing, right? This is a creature of the executive that is not accountable to the executive, that cannot be removed by the executive, that Congress can't control once it's created. Right, so he really loved the nuts and bolts stuff. And the second reason I bring that up is because once he started reciting his dissent, every young law student in that entire room, it was like a chorus of voices rose up, and they were reciting it alongside him from memory, like scripture. Fascinating stuff, right? This is an obscure separation of powers case, but again, his dissents, he's writing them for the next generation of law students. He's writing them for future law students coming up through the ranks in the hopes that his views will one day kind of gain a majority on the Supreme Court.
And on that point, even though he lost in the case in the court, the independent counsel law was later allowed to die. And so it was persuasive in the political arena as well.
We need to move on from the legacy of Scalia to talk a little bit about the current court, because we only have so much time. And I want to ask the panel, Ken, we could start with you. In practical terms, what does a 4-to-4 conservative-liberal divide mean for the court in the near term?
Okay, well, the general rule is you need 5 votes out of 9 to win a decision. If you got a 4-4 split on the court, then you might have evenly divided decisions. And so what's the consequence of that? It means basically that the lower court's decision is allowed to stand. It only has binding effect on that jurisdiction. So if it's a case coming up from, for example, from the Ninth Circuit Court of Appeals here in the West, if there's a decision by the Ninth Circuit Court, the U.S. Supreme Court can't decide whether to affirm or reverse that decision, then that decision will stay in place, but it wouldn't have binding effect on the other circuits throughout the United States. And so there are several cases in this term where we could have that circumstance where a lower court decision is being challenged up to the U.S. Supreme Court, and the court can't reach a 5 vote majority in the case, and so the lower court's decision could be based, it's not necessarily affirmed, but it's basically allowed to stand. Another option the court could choose to do, at least in some cases, is to remand the case back to the lower court for further proceedings, or to hold it over for the next term on the expectation that there would be a new justice at some point in the future, possibly, to fill the 9th seat on the court, so they could have a 5-4 decision.
George, does this 4-4 potential tie give the Chief Justice any opportunities to act as more than just primus inter pares amongst the justices?
Yeah, I mean, I think, given what Ken said, that the Chief Justice could do various things, even when because I think there are 5 really sticky 5-4, what would have been probably 5-4 opinions, now are likely to be 4-4. Maybe one will be 5-3.
4-3.
I'm thinking of Kennedy on abortion. And even after oral argument, it's possible that the Chief Justice could, do various procedural things to sort of kick the can down the road, schedule re-argument. And it wouldn't be altogether surprising if Roberts did something like that. I mean, Roberts he's very concerned with the institutional manner in which the court is perceived, and so far as it's being perceived in very political terms right now, even if I think that they're actually constitutional, political, and in many ways justified, Roberts can't like that. I mean, Roberts is very much a legalist who thinks the court is engaged in interpreting law and playing, as he puts it, the umpire in the system, and so he has to be somewhat skeptical of the politics surrounding it. So I wouldn't be altogether surprising in a few cases something like Roberts did something like that.
Let's talk about a few of these cases that are pending before the court. Some have already been decided, in fact, with Justice Scalia on the bench. Others have been just discussed. In fact, yesterday, as a matter of fact, we had a case, Whole Women's Health versus Cole, that's examining the question of the definition of undue burden in relation to abortion rights. And Amanda, I'm curious what you think in 2 terms. One, what would Scalia do? And secondly, what does it really look like, the decision will look like without Scalia?
So just a little bit of context on this decision and why it matters. Many of you are probably familiar with the Supreme Court's ruling in Roe versus Wade. Roe versus Wade set up a trimester framework for regulating abortion, which swept every abortion regulation currently on the books, off the books in the states. It was a sweeping decision, and it was one that set up a framework for when and to what extent states could regulate abortion, or the access to abortion. Reagan sweeps into office in the 1980s, the Reagan Revolution, and for the first time in a very long time, he's able to mobilize evangelicals into his coalition. And a large part of that was his promise to appoint justices who would overturn Roe versus Wade, or to do something about abortion. He appoints Sandra Day O'Connor, woman justice, as his first justice. And of course, we know he appoints Scalia. And it looks as if by the early 1990s, there's a conservative majority on the Supreme Court that's expressed an interest in states' rights, right? And getting the federal government out of the business of regulating states. And so Planned Parenthood versus Casey was the first sort of test case of whether the Reagan appointees on the Supreme Court could, in fact, provide the critical votes to overturn Roe versus Wade, which is what many evangelicals had hoped when they elected Reagan. It was a split decision, Planned Parenthood versus Casey, and largely thanks to Justice Kennedy and Justice O'Connor. The court says Roe versus Wade is still the law of the land, but we're going to replace that unworkable trimester framework with an undue burden standard. All right, so states cannot place restrictions that present an undue burden on a woman's right to access an abortion after a certain period of time, okay, usually before the viability point. That standard has been tested in various state legislatures, groups who are seeking to limit access or abolish abortion have tested this in regards to various procedures, what is and what is not an undue burden. Those cases have been making their way up to the Supreme Court, and the court hasn't ruled on many of them. So this is really the first test, and it's a very restrictive Texas statute which requires abortion clinics to get admitting privileges in a local hospital, and those admitting privileges are being denied. So de facto, this would eliminate the ability of abortion clinics to comply with the regulation because they are not allowed to get admitting privileges to these hospitals. The question is, does this place an undue burden on the women's right to access an abortion? Or are we just going to say once and for all, Roe versus Wade does not exist, there is not a right to abortion? So de jure or de facto, this case had the ability to overrule, basically, and restrict, make a woman's right to choose an abortion null. I don't think even with Scalia this happens. I think Kennedy has shown himself to be, not that he favors abortion, he is Catholic, but he's been sympathetic to not moving this law too far too fast. And the idea that women have lived their lives as if Roe versus Wade, as if they can have access to this right, and that expectation is important. So we, 5 justices of the court, probably shouldn't tear that up. And so I don't think it makes a material difference. I think it's, the Kennedy goes with the liberals on this one.
Ken, you had a luncheon here not too long ago about this question of reconsidering the definition of total population when we think about reapportioning the U.S. House of Representatives. And it's a case that's pending currently before the court on this very question of how exactly do we count people for the purposes of reapportionment. So what does Scalia's absence mean for that case?
Yeah, so this is the Evenwell versus Abbott case out of Texas, and I see Jerry over there. He argued that case in my class in a Supreme Court simulation exercise, and so he could probably tell you more about the case than I could. But the issue is, in most states, the practice is in drawing district lines, you use census data and you allocate district lines based on the total population of the state, and you make even population distribution in districts based on total population, not based on the number of citizens in a district, the number of voters, or things like that. And so you have even distribution in terms of total people, but you might have wide disparities in terms of the number of voters in a district or the number of citizens. And so a plaintiff in Texas challenged that under the one person, one vote standard, saying that in circumstances in Texas and maybe some other states where there's a large number of non-citizens, you could have wide disparities which dilute the voting strength of people in districts where there are more citizens. And so that's the question before the court, is whether states where you have these wide disparities in voters need to make some sort of adjustment to comply with the one person, one vote standard. It's not entirely clear to me that this splits left-right the old 5-4 way, because I can imagine for some, so liberals on the court would be concerned about the potential effects on minority voting strength or representation in legislatures. But I could also imagine some conservatives being concerned about the Supreme Court going into states and giving more directives to them about what they need to do in terms of redistricting. So I'm not sure that Scalia's absence on this case would make a material difference.
George, here in California, there's a case involving the California Teachers Association that is asking the question, are mandatory public union dues, do they violate the First Amendment? And this is a case that's currently before the court. How does Scalia's absence affect this case?
Let me be really quick on this one so we can talk about the nomination process and Donald Trump and stuff like that. Who I'm sure is highbrow intellectually, Scalia would have really approved of. I think this is the case where Scalia's death makes a profound difference. This was a case, mandatory public union dues, and the question is, can teachers' unions extract from non-members for the purposes of collective bargaining? They can't for political reasons, but teachers brought suit, non-union member teachers brought suit saying, it's all politics, so it violates my First Amendment, right? I think this was one where it looked like 5 justices were willing to overrule precedent from the 70s, but more than that, really sort of thinking that went back to the 1930s. This would have been a huge constitutional shift in our thinking, and Scalia was an essential part of that, and so it looks like we're going to get a 4-4, and the Ninth Circuit Court, which affirmed the lower court and affirmed for the teachers' unions, looks like it will stand. And I think that's the biggest change if you're looking for just specific cases.
Well, let's barrel on in talking about the very fraught nominations process. I think the lines have already been drawn in the sand between the president and Senate Republicans. And we, of course, we have the unpredictable nature of the presidential contest currently happening. In the little bit of time we have left, would someone like to address just a little bit of the prehistory of why it is that in America right now, our federal judicial nominations process, particularly at the Supreme Court level, are so partisan, polarized, and so fraught? And when did it begin?
Do you want me to talk about it?
Sure, go for it.
Yeah. I'm writing a book chapter on this for this book project I'm doing. Maybe you've heard about it. It's for his book project. So in my law and politics class, right, we talk a lot about how there's certain structural and cultural features of the American political system which invite lawyers and judges to play a role in policy making and sort of invite the intermingling between law and politics in ways that just don't happen in the country. And so what I want to say is there are these sort of latent features of our system that have been aggravated over the last 30 years by certain political developments. So one is political polarization. The second is the rise of divided government. And the third is sort of alternating and uncertain control of government. Since the 1980s, the ideological distance between Democrat and Republican elites has grown at an impressive rate. I'm sure you've heard the term political polarization. And political polarization has, it affects the judiciary in 2 important ways. In political science, we like to talk about regime politics theory, that the Supreme Court follows the election returns. Right? Through the nomination, because we have politically selected judiciary, over time the court will start to mirror the values of the governing political regimes. Because control of the White House and the Senate has vacillated between Republicans and Democrats since the 1980s, the pattern of alternating party dominance has produced a correspondingly polarized Supreme Court. Since 2010, the Supreme Court has been strictly divided along partisan lines, with every justice appointed by a Democrat voting more liberally than every justice appointed by a Republican. That's not the historical norm. The Roberts Court is split or sharply divided, so 5-4, on nearly 1 of every 5 decisions, 20% of its decisions, which is double the historical average of how courts usually split in closely divided cases. And as we've seen, the split has produced divided and divisive 5-4 rulings on major issues, such as gun control, voting rights, campaign finance, fair housing. And there's a vicious circle between polarization on the court and the nominating process. So with just 1 swing justice, Kennedy, whoever is president in 2016, now apparently, has the chance to create the first ideologically homogenous voting bloc since the Warren Court in the 1960s. So that's why there's a big old fight over Scalia's seat right now.
One last question before I turn it over to the panel, or I'm sorry, turn it over to you for questions, is on this question of the Senate Republican leadership's actions recently in saying that they will not consider any hearings or any consideration of any nominee that President Obama puts before them. And I'm curious to know, particularly on this question of polarization in the Constitution, is their refusal to hear any nominees a mere political question, that is to say, something that's regular politics? Or is this more of a constitutional one? And what I mean by that specifically is the constitutional process, the normal way of doing constitutional business, is it buckling in some way under partisan stresses?
I think actually not at this point. I'm going to float a silver lining. Potentially.
We could use one, George.
And no, it's Obama is well within his constitutional rights to appoint someone, will and should, and the Senate doesn't have to confirm that person. I mean, it's not even clear that there's a constitutional obligation to give that person a hearing in the immediate future. I mean, I think a lot of the theories that the Republicans have come up with don't, particularly if they're good originalists, don't square with the appointment process, like the people need to have an election to choose the next Supreme Court justice strikes me as a little bit odd. But I do think that insofar as both sides have the constitutional power to make these arguments, and in some ways are on solid constitutional ground insofar as each branch is operating within its sphere, and then they have to defend their actions. I mean, so if it really becomes the centerpiece of the election or an important part of the election, I think then we have an argument about what the Constitution means, how judges should interpret it, right? Why is the Senate engaged in this? Why is Obama pushing a nominee? And I think that could be a healthy thing. I mean, it is not bad for our constitutional democracy to occasionally really engage fundamental and foundational constitutional questions. And I think that would be the silver lining. Republicans look like they're going to nominate Trump. I don't know that I see him making the sort of constitutional arguments that one might want at the time. And if you were a moderate Republican, you might think, good God, let's get Obama to nominate Srinivasi and quickly and confirm him before we lose the Senate and get somebody we really don't want.
Ken?
Yeah, just a quick little bit of context on this. There have been controversies around the Supreme Court many times in our history. The court packing controversy in the 1930s. One interesting case was at the end of the Warren Court area, Chief Justice Earl Warren resigned in mid-1968 when it was clear that Lyndon Johnson was not going to serve a new term. Toward the end of that year, there was a confirmation process. There was a filibuster against Abe Fortas. It was a bipartisan filibuster between conservative Republicans and Southern Democrats. And his nomination to be Chief Justice failed. And this was in an election year. Johnson was replaced by Nixon, and Nixon was able to appoint the next Chief Justice, Warren Burger. And so that's an often forgotten historical thing. And one that's sort of more in the historical memory of a lot of people is the controversy over the nomination of Robert Bork. And for a lot of conservatives, that was the one that sort of changed the game for them and made this whole process a little bit more of a partisan exercise as opposed to just looking at the qualifications of the nominee and trying to make a determination on that basis whether to vote yes or no on the confirmation.
It's also an interesting distinction to say that the Abe Fortas was bipartisan in some way and maybe had institutional roots, where today it does really seem more like it's a partisan question.
It's the parties weren't as neatly divided as they are now. I mean, we are in a period where the partisan polarization is very much feeding into what's going on with this vacancy in the court, absolutely. And so, it's hard to separate out, I think, what the partisan motivations are compared to the constitutional ones.
Well, let's open it up to questions then. I'm hoping that you all have some questions for us. As usual, the preference goes to students for the first question, sorry.
That's it.
Thank you for your talk. I was wondering, after all of this, who you think Obama will nominate and whether that person will actually be confirmed by the Senate.
Go ahead. Ken's got a nice little chart here with various names written down.
I've been kind of looking at this. I mean,
Ken's a baseball fan, so he's got the statistics done here.
Fantasy lineup?
Red Sox.
Okay, there've been all sorts of speculation about various different people and different motivations that the president might have. Is he going to be thinking about the politics of this? Would he nominate somebody who would satisfy some sort of political objective? For example, a Latino or an Asian nominee, another woman, or other part of the Democratic Party constituency. Or would he make a nomination that would really put the pressure on the Senate? The most recent speculation focuses on a federal appellate judge named Jane Kelly, who comes from Iowa, which is, if you're thinking about this, okay, Iowa, what's that relevant to the Senate confirmation process? The chairman of the Judiciary Committee, Chuck Grassley, is from Iowa and has been a supporter of Jane Kelly in the past when she was nominated for the Court of Appeals, she was approved by the Senate on a 96-0 vote, right? So you can imagine those kinds of nominations that would embarrass or put a lot of, make it awkward for the Senate to resist somebody of that type. So I don't know, this is total speculation from my perspective. I don't know what's going on. And do I think it would, the president's nomination would be confirmed? Not in the short term. I can imagine if we get closer to the end, if that nomination is just kind of sitting out there and it looks like the Republicans are going to lose the Senate and it's going to be President Hillary Clinton making the next nomination, I can imagine them sort of reconsidering and doing a quick confirmation vote for somebody that looks better to them than what might be coming in January.
Another question.
Is this on? Yeah. Hi. So at the end of A Matter of Interpretation, Scalia kind of alludes to this idea that the living Constitution actually invites the selection and confirmation process to be politically motivated, and that people are just going to confirm the people that they want. I guess, what do you think Scalia would say about what's going on today?
What would Scalia say? I was right! And on a more serious note, I don't know that...
I'm sure he's saying that right now.
I'm sure he's saying it right now. I don't think it has anything to do with living constitutionalism. I think this is a high-stakes game, and it's been a high-stakes game since the 1980s, and it's only gotten more and more high stakes. And the tactics you see on either side, remember, the Democrats filibustered Alito. They eventually brought him up and confirmed him, but they filibustered him, and conservatives are like, you did this first, right? Latest news is that the Democrats in New Jersey are refusing to bring up Chris Christie's nominee for the New Jersey Supreme Court because he's a lame duck. No hearings, no votes, right? Is this a new pattern, all right, of a party interaction? Is this sustainable over the long term? When does the election year start? Right? Is it 1 year? Is it going to be 16 months? Is it going to be 2 years? Is it after, someone begins their second term? You're a lame duck now. Okay, you really shouldn't nominate any judges or justices. I don't know that I see the silver lining like George does, but I do want to point out that I think we're in a new political order. I think we're in a new political order. I think we have to expect our judges to be activists, because our politics is at a halt, and our political parties are causing gridlock and obstructionism. The courts are the place of last resort where policy is happening. And both sides have abandoned judicial restraint. The liberals never embraced it, and the conservatives have abandoned it, right? So we're all judicial activists now. And the key is going to be who's going to get the most judicial activists on the court.
I actually don't think Scalia is altogether right there. And I mean, I think there's some of it that's right, but interestingly, if you look at the last nomination hearings, they complain that they can't do anything. And the Senate's odd, it could just vote them down, but they really go with, well, is this person qualified or not? Now, you occasionally have outliers who say, I'm not going to vote for you for your constitutional jurisprudence, but on the whole, when it comes to Senate confirmation hearings, the argument really is on their professional qualifications, which is what, say, a Roberts would very much want. It's not clear that that has to be the case, right? And it's odd, so Arlen Specter, a few years ago, when he was senator, asked Elena Kagan, when she was nominated, you wrote this terrific article in the University of Chicago Law Review as a professor, and in that article you said, why doesn't the Senate confront nominees on serious constitutional questions? They ought to during confirmation hearings, not like, hey, what do you think about this particular case, but hey, what do you think about the 10th Amendment? What's the role of the court? Those are all open and legitimate questions. And when Kagan came before the court, she said, well, I can't speak to that. I don't want to speak to that. And Arlen Specter was like, what am I supposed to do? And it's like, you could vote no on this issue. And the Senate could do that. So I don't think Scalia is quite right on that issue. I mean, the Senate, he was 98-0. Many of them have been, and that's because there's a difference between looking at professional qualifications and then looking at constitutional jurisprudence. And it seems to me the Senate could absolutely push those questions. And I think it would be not unhealthy for our politics to push those questions. And so that's, again, the potential silver lining.
We have time for one more question.
As Professor Hollis-Brusky stated earlier, Scalia was kind of known for these dissents that like established like not progressive, but conservative thought for like years in the future. Do you think someone who's currently on the court, Alito, Roberts, Thomas, will take up that mantle, assuming a progressive gets put on the court? And do you think Sotomayor will continue being the progressive side to that, even if she's now on the majority opinion? And will she be writing concurrent opinions, furthering a more progressive style?
That's an interesting point. I would say that Justice Thomas has already staked out a role in sort of advancing a particular judicial philosophy in concurring opinions and otherwise in his jurisprudence. The last point you make about the progressive wing of the court, it's really notable that in many of the leading cases, they have voted together as a group and have not issued a lot of concurring opinions where they sort of advance more philosophical or jurisprudential arguments that would, for example, in Obergefell. Okay, this was a decision written by Justice Kennedy, not really one of the four progressives on the court. There was a lot of controversy over the judicial reasoning, but the four progressives on the court didn't write concurring opinions to sort of advance a different theory or a more progressive theory of the rationale for the decision. So that will be interesting to see if they're, especially if the progressive wing of the court grows, whether you'll start seeing some of the members of that group starting to expand their jurisprudence.
Last comment? Amanda, you look like you
Oh, no, I
wanna
was
say
just going to add, from a political science standpoint, one function that concurrences serve, two functions, are to coalition building and for, other future coalitions. And secondly, signaling. So they're a powerful device by which justices signal the kinds of cases they'd like to hear or the kinds of claims they believe in or the kinds of things that they the way they differ from the other justices and how they hope the law will move, like Ken said. And it is really fascinating that liberals don't take advantage of that. But I don't know if that's because they're ideologically homogenous. They are very ideologically homogenous, but so are the conservatives by traditional measures. But they don't take advantage of signaling like the conservatives have.
Well, it's 1 o'clock, so we have to stop, get back to work, back to class. But thank you all for coming in. Please thank our panel for sharing their scholarship with you tonight.